A young man begged for a second chance. Another defendant rejected a plea deal. A worker who lost everything fought to rebuild his life. Then, a Wisconsin judge made decisions that could change their futures forever. This courtroom session is packed with surprising moments, tough choices, and life-changing opportunities you won't want to miss.
Last hearing we had on 10/8, and the offer was to do the DV class with Mr. Dave Hatch, reduce this to a DC for court costs, and dismiss but read in the crim damage count, but holding open restitution for a period of 60 days to accomplish that.
All right, thank you for refreshing my memory. And we are in victims' rights compliance.
Yes, Your Honor.
Do we know if there is any restitution that's going to be requested?
Not at this time.
Okay. Were you able to do that class?
I made it to one session, and then I just started my new job, and my grandpa drives a tow truck, so it's been a kind of a really big struggle to get to the classes. I was wondering if there's any way I could like set it up for like Washburn or something somehow, or I'm just now eligible to get my license back, so I'll be able to get back and forth easy now.
Well, unfortunately, you can't do it through the Washburn. It has to be through the Burnett County.
Okay.
But I'm okay as long as you talk to Mr. Hatch.
Yeah.
He's okay with extending it. You can let him know in the hearing. Judge said it's okay to extend it because I would rather have you complete that class and get this benefit because you're a young man and you don't really want to have criminal record. But it is going to be important for you to try. And I understand wanting or needing to work with your dad and with the plowing and all of that, especially now. But hopefully you can figure that out. So I'm going to give you a little bit more time to be able to do that. But the first thing you need to do, call Mr. Hatch, okay? And get that worked out with him because he's the one who's in charge of that class. So I'm going to give you a little bit over a month so you can see about doing that. How old are you?
I'm 22, about to be 23 in March.
Oh, you have such a baby little face.
Yeah.
I mean, that's a positive thing. It'll get you far in life. So do you actually tow with your dad? Or not tow, but plow?
Oh, no, I've been working at Jack Link. Sometimes, well, he does tow, but sometimes I'll go with the help, but not lately, really, because I've been working so much, working 12+ hour shifts.
Well, Jack Links, that's a great place to
Oh,
go
yeah.
too. What's your normal work hours?
3 to 3:30 a.m. So,
Okay. That's a long shift.
yeah.
3 to 3:30 a.m. And so you're going to need some sleep. And do you know how to use Zoom?
Yep.
And so if you're able to call in, can you guarantee you're going to be in a good Wi-Fi or internet spot?
Yep.
Why don't we do, I want to give you a little bit of time to sleep. And you said you start at 3?
Yep.
What about 2 o'clock on January 21st? You can call in on Zoom, okay?
Okay.
If you've completed the class by then, maybe you will have completed the class by then, you wouldn't need to come in to that next hearing, but you need to get that, make sure that the state, that Mr. Vila has the completion because he can take care of it by paper.
Yeah.
The only thing that'll be outstanding is that restitution. And so if the victim is seeking restitution, you'll get a notice and we'll have to have a hearing.
Okay.
Okay. So 2 o'clock, January 21st by Zoom. Okay.
Yep.
So you can come up here and get your notice and you're free to go.
All right. Thank you.
Heard in the matter 25 CM 180, State of Wisconsin versus Richard Connors. The state appears through Assistant District Attorney Jose Vila in person. Mr. Connors appears in person without counsel. We're set here today in this matter for a status conference. Is there an offer that can be presented?
Yes. So the offer that was presented again at the last SAS conference on 10/8 was for Mr. Connors to obtain an AODA assessment, and this would drop down to a disorderly conduct for court cost only.
I don't know if you got the message, but I called down and let Smith's office know I was going to do a motion for discovery today. And
That is
You do not wish to accept the offer?
no.
Okay. So he doesn't wish to accept the offer, so it needs to be in writing, what you're asking for in the discovery. You need
Yeah.
to file it. Well, you need to give it to the state in writing, okay?
Where would I turn that in at? Just right at,
To the state. You can file a copy with the court, and you can hand deliver one to Mr. Vila or to his office.
okay,
And discovery is waiting for you whenever you do that.
all
So
right.
you can probably do it, he can probably do it today.
He could do it today. It's ready for him. He just needs to pay and pick it up.
Okay, how much, do you know how much?
It's $15.
$15. So you have to pay for it when you get it. So you could even, if you have $15 today, you can even go and get a piece of paper and pen and write that that's what you want to do. You can give it to the state and pay the $15 and you'll be good to go today.
Okay.
Okay, so what I need to do then is set a status conference because it looks like this is going maybe down the trial track.
Possibly.
Is this your,
This is my case, Your Honor.
oh, right. So I'm going to schedule you for 11:15 on January 5th, 11:15 January 5th. That gives you a month, so you'll have the discovery. Do you have $15 today?
Yep.
Excellent. So you'll be able to look at all that discovery, do all of that stuff, and come back on the 5th. And then I'll know if you want to continue or you want to negotiate with Mr. Vila, okay?
All right.
Come get your notice and you're free to go.
I'm sorry, Judge, I missed that. When was that?
We will go on the record in the matters 25 CT 33, 25 TR 492 and 493, State of Wisconsin versus James Lightfeather. The state appears through Assistant District Attorney Jose Vila in person. Mr. Lightfeather appears in person with his counsel Nicholas White by video conferencing. We're set today in these matters for status conferences. Mr. White, please update the court.
Thanks, Judge. This is a case that is going along the IDIP process. Mr. Lightfeather saved up some money for an AODA. He has that scheduled for next Tuesday at Superior Treatment. He has had contact with Tessa for the IDIP. I think he just needs to do the assessment and kind of formalize the IDIP agreement or contract.
Excellent. I'm glad to hear you got all the money saved. You got it all lined up.
Yes, it's been trying, let me tell you, man, where I work at, the company shut down as of December 19th. So I've been there 2 years and they just all of a sudden just closed it down. So
it's closed for good?
down to December 19th. Yep. So I gotta find another job, which I will.
Mr. Lightfeather, I'm so sorry to hear that. I have been so proud of you. I mean, these are allegations and these are not great allegations, et cetera, et cetera.
Sure.
However, but I've been so proud of you and how you've been rebuilding your life and becoming more stable and responsible.
Yeah.
And
the life
so
I used to live was
not
not good. No.
And I'm so sorry to hear about the closing of your job because you were doing so great. I know you're going to find another one.
Yeah.
You're going to get right back on track.
Where?
I'm very hopeful. What I'm going to do is I'm going to schedule you a bit out. How about that February 2nd at 1:30 date? Just
That
to
makes
get-
sense.
Just to get a status to see where you are. Mr. Lightfeather, for a status there, if you still need things to do to complete it or whatnot, you can appear by telephone. So you don't have to drive from Superior to get here. Or you can do Zoom if you figure that out or know how to do Zoom. So we'll do February 2nd at 1:30. You can come get your notice and you're free to go.
Thank you.
Thank you. Mr. Natanoki.
In a Wisconsin courtroom, several defendants stood before the judge, each facing a different challenge and a different path forward. The first case involved 22-year-old Christian Madison. He had been offered a chance to avoid a lasting criminal record by completing a domestic violence education program. However, balancing a demanding work schedule and transportation problems made attending classes difficult. Rather than punish him, the judge chose to give him more time. She encouraged him to stay committed, reminding him that completing the program could help protect his future. The exchange became even more personal when the judge commented on his youthful appearance and expressed hope that he would take advantage of the opportunity being offered. Next came Richard Connors. Unlike Madison, Connors decided not to accept the prosecutor's plea offer. Instead, he requested discovery evidence and prepared to move his case forward. The judge carefully explained the process, informing him that all he needed was a written request and a small fee to obtain the evidence. With trial possibilities ahead, his case was scheduled for another status hearing. The courtroom then turned to James Lightfeather, who had been making significant progress in rebuilding his life. He had saved enough money for a substance abuse assessment and was working toward entering a diversion program. During the hearing, Lightfeather revealed that the company where he had worked for 2 years suddenly shut down, leaving him unemployed. The judge expressed genuine sympathy, praising his efforts to turn his life around and encouraging him to stay focused despite the setback. Another defendant, Skylar Nadno, appeared with his attorney to face charges related to an OWI case. After entering not guilty pleas, he expressed interest in participating in Wisconsin's intoxicated driver intervention program. The judge explained how completing the program could provide important benefits and potentially reduce the impact of mandatory penalties. Finally, Michael Eads appeared with counsel and chose to waive his preliminary hearing. The judge carefully questioned him to ensure he understood the rights he was giving up, including the possibility of challenging the state's evidence. After confirming that his decision was voluntary, the court accepted the waiver and moved the case toward arraignment. Throughout the session, the judge balanced accountability with compassion, offering guidance, second chances, and clear explanations of the legal process. It was a powerful reminder that every courtroom appearance represents a real person facing life-changing decisions and uncertain futures.
Let me know that you're in the program or etc. And then we'll know where we're going to go from there. Okay.
Okay.
All right. You can come up and get your notice. Anything else, Mr. White?
No, Your Honor, that was it.
All right. Anything, Mr. Vila?
Not from my perspective, Your Honor.
Thank you. Then we are adjourned. We will go on the record in the matter 25 CF 127, 25 TR 780, 837, and 838, State of Wisconsin versus Michael Eads. The state appears through Assistant District Attorney Jose Vila in person. Mr. Eads appears in person with his counsel, Daniel Chapman, by video conferencing. We're set here today in these matters for status conferences. Mr. Chapman, please update the court.
Your Honor, we're prepared to waive the preliminary hearing outright today and go to arraignment if the state is ready. And I'd ask that all of the traffic tickets be entered a not guilty plea if it hasn't been done so, and track along with the criminal case.
Do you understand what it is to have a preliminary hearing, Mr. Eads?
Yes.
Your attorney thoroughly went over that with you?
Yes.
Do you understand that the state has the burden to prove a felony was probably committed and probably committed by you?
Yes.
Do you understand that if you waive that right to a preliminary hearing, you are agreeing the state can at least meet that burden?
Yes.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, call witnesses to testify for you, would be able to produce evidence on your behalf, or possibly discover things about the case, which could include defenses. But for this hearing only, you're giving up those rights?
Yes.
Do you understand that if the state does not meet its burden at the preliminary hearing, I could reduce a felony to a misdemeanor or dismiss it altogether, but you're giving up that right today?
Yes.
Do you understand that once you give up the right, it is forever and you cannot get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary